Just as we're letting people join, I just wanted to draw your attention to some of our forthcoming training and events, which are on the screen now. We've got a range of free webinars, some longer courses online, and some in-person courses coming up over the year. And you can view the full programme for this on our website, surreylawsociety.org.uk. We've also just got a few housekeeping notes for the session. So if you'd like to ask a question during the webinar, please use the Q&A facility, which is like a chat box. You can do this anonymously by ticking the Send Anonymously checkbox. Christopher will also be inviting questions at the end of the session. So if you'd like to speak to him then, click on the raise hand function and you'll be invited to talk. Just lastly to note that this session is being recorded. The session's being kindly sponsored by Finders International, and I'll now pass over to Louise Levine, who's going to chair the session from here on in. Thanks, Louise.
Okay, thanks, Helen. Hello there. So my name is Louise Levine. I'm the International Asset Services Manager at Finders, and I'm a little bit of a novice at this particular part of it, so do please bear with me. I'm going to take a moment just to talk very briefly about what Finders does. For those of you who already know us, perhaps make you aware of the full range of the services. And then after that, I will introduce Christopher. So bear with me while I just share my screen. Hopefully that's working fine. So Finders has been around a while. We have been around since 1997. And sorry, I'm just going to quickly flick through some screens here. We work on thousands of estates, and we primarily, but not necessarily, work for estate practitioners, executors, legal professionals, but we also do lots of work for deputyship teams, appointeeship teams, and hospitals and coroners. We're a trusted voice in the media, and we work to a professional conduct code. We're best known for tracing missing beneficiaries, whether that's on intestacy or legatees. We also verify family trees, and that's a growing area of work for us. But there's a whole range of people that we're able to find, some indication here on the screen. We have various ways in which we can charge for the work. We're certainly not limited to just one. And we are also an FCA authorized agent for the insurer Aviva. We have a very long-standing relationship with them, so we can provide missing beneficiary insurance policies, as well as other kinds of insurance, including missing will. One area that we work of many is that it's no longer, and hasn't been for some time, necessary to involve the government legal department. If you have an estate where there are believed not to be any heirs, it's possible for us to undertake some work to locate a potential administrator and to help you secure instructions to administer the estate. Another area where we do lots of work is with deputyship or appointeeship teams, as well as empty property offices. They will refer matters to us, and that enables us in turn to refer matters back onto you to enable you to secure work. We also do lots and lots of statutory will work, which means a notification process in terms of verifying a tree and finding potentially entitled people. Our legal support services team does a number of different services, but the most popular by far, I would say, would be the Overseas Bankruptcy Search Service. So that's at the point of an interim or final distribution, and you're looking to make sure that your overseas resident beneficiaries are not bankrupt. And we also do a missing will search service. Off the back of that, we're then able to get Aviva insurance cover so that you can be sure that you've got either the latest will or that there is no will, for example. We also look for missing documents, so it could be our part of the nil-red band service that you need a marriage certificate or a death or divorce certificate. And we always produce estate distribution schedules off the back of the research that we do to verify family trees. As I say, that's a growing area. It's really a matter of risk and protecting yourselves as executors or partners to make sure that the information that you've been given is in fact correct before making distribution. A perhaps slightly newer area of what we do is the probate property support service. And there's a few instances of the ways in which we can work up on the screen here, so I won't go through them all, but do by all means contact our dedicated property services manager, Saida Abhishek, and her team, who can help. And I think this is particularly useful and of interest to our clients where the property might be in a great state of dilapidation, or it might be hoarded, there may be biohazard, or it might be far away, or for that matter, all of those things. And where there is distance, particularly, I think that what we're finding is that our clients are really appreciative of having a service with this kind of reach that they can get to the property, secure it, clear it insure it, value chattels, and so on. Excuse me. When it comes to overseas assets, that's the team that I head up, then we're talking really here about the ease with which people can acquire assets overseas, whether that's bank accounts, money offshore, shares held all over the place, and sometimes no action at all because they were simply acquired through corporate action. What tends to link these issues is that a gate comes down when the death has taken place. Lots of assets get frozen, and a series of often increasingly tortuous requirements have to be met in order to get those assets either liquidated or sold or closed, and the money's back into the UK. And this is where we come in. What we find is that certain issues come up again and again, whether it's compliance or there are practical issues, there are tax issues. For example, there might be a high value estate in the US and tax clearance is needed, which is a very lengthy process, 2 years on average at the moment. There could be simply cultural issues between one institution in one country and in the UK. And what we often find is that the expectations of the executors or the beneficiaries are that everything is going to be a little bit like closing a UK bank account, and it very rarely is, as we can certainly attest. So a very brief instance of the kind of things that we can do is on this screen here, from medallion guarantee stamps to selling US shares or shares in Canada. We can reseal, we get offshore grants. What we're doing is making use of both knowledge that we've acquired over many years, but also a network of agents and partners and people who can assist us with this work. So my general suggestion is that if you think you've got something like this and either you've already had this kind of problem or you simply don't have the time to deal with this element of the estate administration, then it's always a good idea to just give me a call or drop me an email, and we can talk about what you need, whether it's feasible and worthwhile for us to get involved or assist. We always try to give at least some advice, even if we can't actually help. We can talk about the costs of the work, which are usually very bespoke. So that's pretty much it from me. By all means, contact us. The simplest and best way is either through one of our online forms or using our contact@ email address. You can also contact me directly. You can find me on our website. So that's pretty much that. Now, the next bit, I must admit, I didn't rehearse, is how to unshare my screen. Bear with me for a moment and I will see if I can do that. Just about to hand over to you. Thank you for rescuing me there. So I just wanted to introduce Christopher for you all. So Christopher is a Chancery barrister and he specialises in contentious probate claims and the law of real and personal property. He's going to talk to you about a number of things and give you an update on contentious probate matters, including insane delusions and the test for testamentary capacity, expert evidence and the golden rule, and catch you up on the proprietary estoppel issue that's currently being discussed in the Supreme Court. So with no further ado, thank you very much, Christopher. Over to you now.
Thank you, Louise, for introducing me, and also thank you, Helen, for inviting me to do this webinar today. I actually do quite a lot of webinars for my chambers, and today's presented a slightly new challenge, because the usual way that I would do one is I'd just choose, say, for example, a particular topic like mutual wills and speak about it for an hour or so. But trying to break this webinar down into 4 categories or 4 or 5 categories and still cover enough detail has been interesting in terms of preparation. But I hope that you will all get a useful, or you'll all take a flavour of those topics away from this and get something useful out of it. As you'll see on the slide, I've put my email address here. I will be taking questions at the end of the webinar based on the topics that we're talking about, because in these webinars, in webinars, you often get people asking questions about their specific cases. Happy to answer, advise you on the specific cases, but that needs to be on a formal basis. If you want to ask me questions about the topics, then they should be theoretical. But if you have any questions and you don't feel comfortable about asking them in the webinar, or you just would prefer just to contact me directly, then please feel free to drop me an email or link in with me, and we can discuss it from there. Now, the first topic that, or alternately, if you just want to say hello, it's always nice to meet new people. Now, the first topic that I'm going to look at today, if my slide will change, is a case that relates to testamentary capacity. And testamentary capacity is an area that I find particularly interesting. And I'm sure most of you are noticing that there at the moment there is an increase in the amount of challenges based on testamentary capacity, which presumably is as a result of factors such as the increased prevalence of diseases such as Alzheimer's disease and so forth. But as you all, well, as I suspect most of you all know, the common law test for testamentary capacity was set out over 152 years ago by Lord Justice Cockburn in Banks and Goodfellow, and it sets out 4 limbs. But the word "shall understand" in the test does not mean that one needs actual understanding, or does not mean that there needs to be proof of actual understanding. What the test is looking at is whether there's the capacity to understand and the ability to make decisions. And the question of whether somebody has sufficient capacity has to be considered in the context of the transaction that's being made and the complexity of the estate. And there's been a number of cases since the Mental Capacity Act came out about whether the common law test should continue to apply, or whether the Mental Capacity Act test should supersede it or supplement it. And there's cases such as Scammell and Farmer, Walker and Badman, James and James, where the High Court considered this issue. The main approach has been that, the consistent approach really has been that the courts, apart from a few Overton comments, has been that Banks and Goodfellow should continue to apply as the retrospective test for capacity. Now, there are some fundamental differences between those tests, and the most fundamental of the differences being that there's a different burden of proof. As under the Mental Capacity Act 2005, capacity is presumed, but as you'll be aware, at common law, you have a number of presumptions and counter presumptions, and the burden of establishing capacity initially lies with the propounder of the will. But if the will is duly executed and rational on its face, then the court will presume capacity, and the evidential burden will shift to the objector to show that there is some real doubt as to capacity. And if they show a real doubt, then the burden shifts back to the propounder to prove capacity. There are also a number of key differences between the degree of understanding at the relevant time and the degree of understanding as to the consequences of making a will. And this argument, as I said before, has popped up in a number of different cases, and it was raised again in Clitheroe and Bond, and which is the case that we're going to look at in a second. But as the matter was not argued at trial in front of the Deputy Master, Mrs. Justice Falk did not. Well, she took after reviewing the relevant authorities on whether you should permit a point to be taken that wasn't taken at first instance. She came to the view that it wouldn't be in the interest of justice to allow it to be raised on appeal. However, as she had heard argument on the point, she did express an overture view as to why she believes the Banks and Goodfellow test continues to apply. But as it's overture, I'm not going to go into it today. What we're going to actually look at is the test for delusions, which is the important part of Mrs. Justice Falk's decision. Now, shortly before this webinar, I went to switch on my slide, or went to upload my slides, and found that none of them had been saved. So I've gone through my slides and tried to recreate them as best as possible, but they're not as smooth as they should have been. But if we, and there may be a couple that are missing, but I've recreated them as best I can from memory. But before we delve into the main point in Clitheroe and Bond, I should probably provide some background in relation to the facts of that case. And the case involved a dispute between two adult siblings in relation to the validity of their mother's will. And the will was challenged on two grounds. Firstly, it was challenged on the basis that the mother lacked capacity. And secondly, that the will was a result of fraudulent calumny. However, the allegation of fraudulent calumny was rejected at first instance, and it didn't feature on appeal, so I won't mention it any further. But by way of very brief factual narrative, the essential elements, the essential facts were that the deceased had 3 children: Deborah, Sue, and a son called John. And unfortunately, the eldest daughter, Deborah, passed away due to terminal skin cancer. And this, sadly, as one would expect, had a rather profound effect on the mother, who took to her bed for a considerable amount of time. But there was an argument that happened while Deborah was terminally ill between the mother and the other daughter, Sue, about the administration of morphine to Deborah. And sadly, the mother was then admitted to hospital. She, at that stage, Sue was visited every day. When she came out, an estrangement arose between them, and they unfortunately didn't see each other much. Now, the judge at first instance, Deputy Master Linwood, I think it was, held that the estrangement was mainly due to the mother taking an irrational grudge against Sue. And the mother had made 2 wills. The first, well, after the period of when Deborah died, the first will was executed in 2010, shortly before she was admitted to hospital. And then there was a second will in 2013. Presumably, there was disclosure of the will file because there's a number of references to different references to the attendance notes and so forth. And it became clear from or the judgment sets out that the 2010 will was made with some haste, and there wasn't a face-to-face meeting to take instructions. In that will, after a few gifts of chattels and a few small legacies, the residual estate was to pass to the son. And again, in the 2013 will, it was largely the same. There was a few changes in the chattels bequested and the legacies, but again, the key point was that the residual estate was going to pass to the son. But where the case starts to get interesting from the factual narrative is that the instructions that were given to the solicitor had a number of reasons as to, well, because there was various different instructions. The initial instructions for the 2010 will were suggesting that that Sue was, or alleging that Sue was, that Sue was the shopaholic, and that she would fritter the money away if anything was left to her, and that's why things weren't being left to her. But there was also notes that were delivered to the will drafter. And amongst other things, the testator had said words to the effect that John was doing everything for her, and that if it was left to Sue, that she would be left to starve. And there was also allegations that Sue was preventing her from seeing her granddaughter, and allegations of theft. And these were repeated when the legal executive attended upon her to execute the will. Now, with that in mind, we can turn to the key point of the decision, which is Mrs. Justice Folke's comments on the test in relation to delusions. And in this case, both parties had the benefit of expert evidence. And incidentally, actually, one of the parties had Professor Robin Jacobi, who is, as I'm sure most of you all know, is an eminent and leading expert in geriatric psychiatry. And slightly off point, actually, there's an interesting, just while it's in my mind, there's an interesting point that Professor Jacobi made in a case called McCabe and McCabe, that you should be aware of if you deal with a lot of these cases. which was he was saying that if you deal with these cases, you'll quite often have to review medical records. And one of the things that you'll consistently see in the medical records is the assessments that the doctors are doing, to, especially with dementia type cases, to see whether somebody has certain, whether they qualify on the scoring systems for dementia. And also, when we talk about dementia, it's important to remember that dementia is a syndrome. It is not a pathological disease. That there is something underlying that causes dementia. But there's a number of different tests that the doctors, that GPs or psychiatrists tend to apply to assess somebody's capacity and see whether they have, whether they're suffering from dementia. You have one of the most common ones that you see is the MNSE test, but you also have the ACE test. And in McCabe and McCabe, Professor Jacoby's evidence was that the ACE is more accurate in identifying true and positive negatives in relation to dementia, because it's more extensive test. But that's slightly off point and not relevant to what we're talking about. So back to the point at hand. Amongst a number of other things, there was an allegation that the deputy master had fallen into error by failing to consider whether it was impossible to reason the testator out of the beliefs, relevant beliefs. And this argument was mainly based on Williams on wills, which cited that as a principle relying on the case of Dew and Clark, which is a Georgian case. Now, the deputy master found that it was not necessary to show that it was impossible to reason the person out of their belief, and that although, and so that was and this was the key point that was being looked at the appeal. Mrs. Justice Folk reviewed during Clark and found that there was support for that proposition, but she then went on to say that she didn't agree that during Clark laid down an absolute rule that a delusion can only exist if it's shown that it's impossible to reason the individual out of the belief. Further, it was argued by a leading counsel in that case that although it was not essential to the test, that attempts were made to reason the person out of their beliefs, it must nevertheless be shown that it's impossible to do so if it were attempted. And they qualified that submission slightly by saying that in some cases, such as Smith and Tebbit, which it is quite an extreme case because it was to do with, it was a situation where the deceased in that case thought that she was part of the Holy Trinity and that she thought that she was the Holy Spirit. And they qualified their argument slightly by saying, well, in that type of scenario, very little additional evidence was required. However, it was argued that in Clitheroe and Bond, that wasn't the case. Now, the judgment is illuminating, and the key points begin around 102 of that judgment, paragraph 102, because what the learned judge was stating, as you'll see from the slide, is that the false belief must not be a simple mistake that can be corrected. It must be irrational and fixed in nature, and be out of keeping with the person's background. And the learned judge then went on to say that where you have an extreme delusion, like in Smith and Tebbit, which was the case I was just talking about a moment ago, it's not going to be difficult to prove that delusion. However, a lot of cases will not be that extreme. And one way of demonstrating that there is a delusion will be to show that the person can't be reasoned out of it. And the important part of this passage is that she then goes on to say, however, this is not an essential part of the test, but rather is a means of proving that the test is satisfied. But, and then following that, she went on to point out that there are a number of other ways in which you can also prove that the test is satisfied. For example, if a belief is maintained where there's clear evidence to the contrary, and there's nothing to suggest that the person has simply forgotten the true position, then that's likely to prove that there is a delusion. But what is key is that the belief is fixed. And in the next slide, next two slides, I've just set out another couple of interesting parts of that judgment, which you can read in your own time. But just before we move on from this point, because I realise that time is pressing on, I should just make clear that the false belief needs to be morbid in origin. And what I mean by this is that it needs to be derived from the mental illness, and that there must be a causal connection between the delusion and the decision in relation to the property and the will. Further, although the fourth limb refers to delusions, the word delusion at the time, you have to view it in the context of when that statement was made, which was over 150 years ago. So the word delusion is now taken to apply to any disorder of the mind. Now, turning to our next topic, which again is a very interesting case by the name of Sismey and Salandron, which was an unreported case. And if you get a chance, I suggest having a read of this case, because in very simple terms, it involves the enforceability of the divorce settlement against a testator's estate. But what's interesting about the case is that the court looked at how Section 11 of the Inheritance Act, or Inheritance Provision for Family Independence Act 1975, which I'm just going to refer to as the Inheritance Act, applies in a situation where the deceased had split up from his wife, and in a consent order, he had settled financial remedy proceedings and had agreed to execute a deed of covenant whereby he would, where he covenanted that he would execute a will leaving the former matrimonial home to his the son from his first marriage. Now, I should set out just clarify some of the facts on this case. First of all, the property in question was actually bought prior to the marriage, and it was bought in his sole name, but it was the property at which the family resided at during the marriage. And Mr. Sismey worked overseas, and during the period when he was working overseas, he met another woman who was named Marissa, and began a relationship with her. Now, he then told his wife Sheila of the relationship, and Thomas, and the son of the first marriage, moved out, and Sheila moved out of the property. The relationship with Marissa produced a son called John, and it took a number of years for the couple to be able to sort out Marissa's immigration status. And then in the judgment, there's quite a bit about the need to resolve the family proceedings in order to in some way assist the visa application. Now, the deed of covenant that he entered into stated that it was to buy that the deceased was covenanting to bind his personal representatives to leave irrevocably in his lifetime by will the property for the benefit of Thomas. And the deed also provided that it was intended to be enforceable by Sheila or Thomas. And as I'm sure most of you are aware, a will is by its very nature a revocable document. So because as His Honour Judge Paul Matthews pointed out in James and James, it's ambulatory in nature, because what it reflects is the person's current intentions. However, you can bind yourself to leave your property by will. You can enter into a contract with that, but it tends to be really in two different situations. So the first tends to be mutual wills, and as you'll be aware, the trust arises, and then you have the other is is in divorce settlements. That I understand that there tends to be these type of clauses put in. Now, there's an interesting point about what you can covenant to, because it's and there's quite a bit of case law on it. But anyway, that's outside of what we need to look at for the purposes today. Now, as I said before, the deed provided for Thomas to be able to enforce the deed, and that's important because under Section 1 of the Contracts or Rights of Third Parties Act, it gave him the relevant locus to be able to bring proceedings to seek performance in specie. Now, in accordance with what had been agreed, the deceased did execute a will that left the property to Thomas, with the residue to pass to Thomas and John equally. But after I think the property made up around 190,000 of the estate, but there was only, I think, around 13,000 in the residuary estate. So this was the key asset that was in play, so to speak. Now, unfortunately, Mr. Sismey was diagnosed with terminal cancer, and upon being shortly after being diagnosed with terminal cancer, he proposed to, or decided to marry Marissa, and it was accepted in evidence that part of the reason why Marissa and Mr. Sismey were getting married was so that Marissa could benefit from his receive the widow's benefit from his pension. But the consequence of the marriage meant that the will, pursuant to Section 18 of the Wills Act, was now revoked. And as a result of this, Thomas, after the death of his father, brought a claim for specific performance of the deed of covenant, and in the alternative argued that a constructed trust had arisen. And the principal defence that was raised was that the deed did not comply with Section 2 of the Law, Property and Miscellaneous Provisions Act, because the argument was that it didn't contain all of the relevant information within the terms of the contract. Marissa, however, also brought proceedings for reasonable financial provision under Section 2 of the Inheritance Act, and she also brought an application under Section 11 of the Inheritance Act, which is the point that we're going to come to in a moment, which is the key point of the case. Now, the judge rejected with a contract to leave property by a will. You have to have a number of certainties in order for that contract to be enforceable. First, there must be a enforceable contract at law. So an expression, an expression of mere intention will not suffice. There has to be an enforceable agreement. Secondly, there must be a certainty of the subject matter. And thirdly, in the cases in relation to real property, but it needs to comply with Section 2 of the Law, Property and Miscellaneous Provisions Act 1989. And if you're looking for a third party to be able to enforce that document, you would also, the fourth criteria would be that it needs to be compliant with Section 1 of the Contract Rights of Third Parties Act. Now, in Sismey, the first 2 points were accepted, and there was an argument about whether the contract incorporated all of the terms, because one of the consideration was set out in the consent order rather than the deed of covenant. But as the deed of covenant used the word supplemental to, the judge took the view that the objective reader would realise that the deed could not be read in isolation and had to be read in conjunction with the consent order. But as I was saying before, that's not the point that was interesting in the case, because the point that's interesting is the Section 11 provisions. And by way of very sort of quick general overview, Section 11 in the Inheritance Act provides the court with a discretionary power pursuant to section 11.2 of the Act, that and subject to the conditions in 11.2, 12 and 13 being satisfied, to make an order that a donee who has received a sum of money or a transfer of property pursuant to a contract to leave property by a will shall pay a sum of money or shall provide some other property. There's a second type of order that can be made, which is where the court can, where no money or property has been paid, the court can order that the PR will not give effect to the contract. However, these powers are fettered, and section 11.3 of the Inheritance Act provides that the court can only exercise these powers in relation to the amount that exceeds any valuable consideration that was given for the contract. And when you're considering this, pardon me, when you're considering, and when the court's considering to exercise its discretion, the court will take into account a number of different factors which are set out at 11.4 of the Inheritance Act, such as factors factors like the circumstances in which the contract was made, the relationship, if any, with the donee of the deceased, and the conduct and financial resources of the donee, and any other relevant circumstances. You also have a provision in relation to section 10 in relation to trusts that's also just for your knowledge. Now, to exercise that discretion, the court has to, or to exercise that power, the court has to be satisfied of a number of conditions. First is there must be a contract. Second is that the contract must be made with the intention of defeating an application for financial provision under the Act. And by virtue of section 12 of the Act, the intention does not have to be the sole intention of the deceased, but the court must be of the opinion that it was his or her intention to prevent financial provision being made under the Act, or to reduce the amount of the provision that might be provided. Thirdly, that valuable consideration, the third criteria, which is important for this present case, is that full valuable consideration was not given or promised. And fourthly, if the court exercised its powers, it would enable financial provision to be provided to the applicant. Now, the wording of the third criteria is interesting, as consideration in contract law does not need to be adequate, it just needs to be of some value. So the word full before the word valuable consideration clearly shows what the court is looking at in these types of cases is the adequacy of consideration, and is addressing the situation, addressing the type of situation where an agreement gives rise to a transfer and an undervalue. Now, I use the word transfer and undervalue deliberately to avoid any confusion with the term transaction and undervalue, which is a term within insolvency, but there is an overlap. There is the transaction and undervalue cases are looked at by analogy in this situation, and it's something that you'll see if you read this case. One can see from Sismey that when you're judging this question, you have to look at the time that the contract was being made, and one of the other points to note in Sismey was that the consideration actually came from Sheila, the mother, rather than from Thomas, but it was conceded that was sufficient for the purposes of the Act. Further, and interestingly, in section 12 of the Act, there is a provision which sets out that where no consideration has been given, it is presumed, unless the contrary is shown, that the deceased made the contract with the intention of defeating an application for financial provision. Now, I'm sure that in a lot of your minds you'll be thinking the same thing as I thought when I read that, which is, if that can only be directed at one thing, it must be directed at a deed, because a deed doesn't require consideration. But as we know, a contract needs consideration unless it's made by deed. So, and one of the criteria of falling within one of the criteria you have to satisfy is that there is a contract. So clearly this provision must be aimed at deeds where you have consideration. But going back to Sismey anyway, the court found in Sismey that there was clear evidence that there was an intention to defeat a claim for financial provision, and that the intention does not have to be the dominant or subsidiary. It doesn't have to be the dominant motive. It can be a subsidiary but material motive. And they then went on to consider whether the deceased and Sheila had acted collusively. And the reason that they went on to consider this point, or the judge went on to consider this point, was that, as I mentioned a moment ago, you have an analogy that can be drawn with insolvency cases, such as cases like Hill and Haynes, where the courts have had to consider whether the compromise of financial remedy proceedings constitutes full consideration for the purposes of section 339 of the Insolvency Act, which is in relation to transactions at an undervalue. And in the case of Hills and Haynes, the Court of Appeal held that giving up an ancillary relief claim would constitute consideration, and a trustee and that a trustee in bankruptcy would be able to challenge or would be able to seek to set aside an order if there was vitiating circumstances, such as the usual vitiating circumstances of fraud, misrepresentation, or there was collusion between the spouses to defraud the creditors. So applying that by analogy, the learned judge accepted that even if Marissa, one of the other key factors in this case was that Marissa had actually signed the consent order, and that she had no interest in the property, but that even though she had done that, the judge found that clearly that Sheila and David, i.e. the deceased, had colluded in order to try and prevent an identifiable risk, which was that Marissa would at some time in the future bring a claim for financial provision. So because there was collusion, the court then took the unusual step of looking into or inquiring into whether there was value for the consideration. However, having done so, the court held that Marissa's claim failed, as she could not satisfy that criteria, i.e. that there was the full valuable consideration not given, that there was anything above that. So as I say, it's an interesting case and you should read it. One point I should just make though, just in case there's any confusion, to bring a section 11 application, you have to also bring a section 2 application. So the section 2 application is bringing for reasonable financial provision, and then section 11 is coupled onto it if you're seeking to essentially get the benefit of those orders. Now, the next point, the next topic that we're going to cover is in relation to the case of Guest and Guest, which is an appeal arising from a proprietary estoppel case, which was heard by the Supreme Court in December, but as of yet, the decision's not been handed down. And if you know me, you know that I find proprietary estoppel, I also find proprietary estoppel a very interesting topic. In fact, I'm actually doing a series of webinars on proprietary estoppel at the moment for Chambers. And although there's a lively, I must say that I was slightly surprised that the Supreme Court took this case, because although there's a lively debate in relation to the point that they're asked to consider, which is whether the claimant's expectation is the appropriate starting point, there is, these cases are extremely fact specific. And the flexibility is actually a benefit. The flexibility in the approach to the remedy is actually, I think, a benefit. But I understand that when you're exercising discretion, you have to, essentially what they'll be wanting to do is provide some guidance as to how that exercise the discretion. So it should be, but there already is. So it'll be interesting to see what they decide. But before we look at the key point that's being determined in that case, I should just give you a brief overview to make sure everybody understands proprietary estoppel, the basic concepts. And this is intended to be a very brief overview. So at the risk of oversimplification, I'll just rattle through a couple of key principles. Proprietary estoppel is an area which really has benefited greatly from the strong academic contribution in relation to it. And you have a couple of academics in particular, or notable academics in particular. You have Ben McFarlane, John Mee, Andrew Robertson, and a number of others. But with Ben McFarlane and John Mee, they argue that that you can categorize proprietary estoppel cases into three types into three strands that are intended to address different types of unconscionable behavior. So those strands are that there's an acquiescence-based proprietary estoppel, where somebody just stands back, and I think Lord Newberger described that as a classic case. A representation-based strand and a promise-based strand, but it's the promise-based strand which is the type of case that one sees in a succession context, and it's the one that is probably is the one that's most growing at the moment and most interesting. Now, as interesting as those arguments on taxonomy are, they're not directly relevant to what we're going to talk about today. But if you are interested in it, I would suggest if you send me an email, I'll quite happily direct you to the relevant literature so that you can read about the theory behind it yourself. I'm a bit of a geek like that. I read law books like people read novels. But the basic elements of proprietary estoppel is that you have, or promise-based proprietary estoppel, well, basic elements of proprietary estoppel full stop is that there's a promise or assurance made to the claimant by the defendant, and the claimant reasonably relies on that assurance to his detriment. Now, some of you may be thinking, how does that fit with acquiescence? Well, the way it fits with acquiescence is seen or argued to be an implied assurance. And that's the kind of the headlines that are put. But if you were setting out the sort of classic promise-based proprietary estoppel example scenario, it would be in relation to a farm. So say if we have a character called Charles, who works for next to nothing for, say, 30 years on the assurance, very long hours, on the assurance from David, who can be either his father or a friend, doesn't really matter, that he'll one day inherit the farm. And Charles positions his life on that basis, but David doesn't leave him the farm. Now, what you do, that's the sort of classic example that you have in these types of cases, but obviously it's not limited to that factual nexus. It can apply to various different types of facts, but the approach that you would have is you would look at the point at which the promise falls to be performed, and look, it's a retrospective exercise. You'd look back to see whether an equity is being raised. But as I was saying before, there is the description I gave a moment ago is really just the headlines, it's the bare bones, because there are a number of detailed points that feed into those. So just for example, you have, with a promise or assurance, the promise or assurance has to create an expectation in identifiable property. You also have to have a causal link between the promise or the assurance that's being relied on and the detriments that's being asserted. But as I was saying, that this is just a sort of very brief overview. That there's a lot more detail that goes into it. Now, with those points in mind, oh, actually, another point I should just pick up on very quickly is that which I think it was in Gillett and Holt, it was sent out by Lord Justice Walker, as he then was, that you have that although you have these different elements, they are not watertight compartments. So they are things that there is often a substantial degree of overlap between. For example, reliance and detriment are usually intertwined, and the context and quality of the promise will influence whether it's reasonable to rely on it. So there's a great deal of overlap in these principles, but and what one really needs to do is when you approach the proprietary estoppel, you need to take a holistic view and stand back and look at the elements of the whole, rather than thinking of them as it like checkpoint, or checkbox, ticking a checkbox. Actually, just while we're on the point, Lord Justice Robert Walker, as he then was, who became Lord Walker, is, if you're familiar with these cases, he is one of the key players in developing this area of law. And if you're reading judgments and he's given a judgment, always on proprietary estoppel, always read his judgment, because it's he is responsible for a lot of the key principles in it. Now, with that brief overview in mind, let's turn to the point in guest and guest, which is, as I mentioned before, the Supreme Court is looking at whether the claimant's expectation is the appropriate starting point when granting relief. Now, in relation to relief, what one is looking at is how to satisfy the equity that has arisen by virtue of the claimant relying to his detriment on the promise. As such, you've got, you have theoretically, as such, there are two ways that you could theoretically approach this, maybe more, but there are two main ways that you could approach it. The first would be to give effect to the expectation, and the second would be to remove the detriment. These approaches can have very different outcomes. And if we use the farming example again, it may be that the farm was worth millions, but Charles would have only earned 400,000 if he'd gone to work somewhere else. So you could argue on the expectation point, you would be arguing for millions. On the detriment point, people could be saying, well, actually, he couldn't have made anything more. This is what his detriment is, but I would actually argue that that's not entirely correct, but I'll come to that in a moment. But there's a significant disparity. Well, it depends on the facts. So that is an argument that can be run, but it depends on the facts, which I'll come to in a moment. But there's a potential significant disparity between these two types of potential remedies. And if one considers the two approaches in the abstract, there is, at least in my opinion, an obvious attraction to satisfying the equity, because there's logical force because the expectation is what's been created. However, I do accept that there's logical force in the alternative, which is because if you remove the detriment, then you remove the unconscionability that makes. If you remove the detriment, you remove what makes it unconscionable for the promisor to resolve from the promise. So you essentially remove the foundation of the equity. The claimant has no cause for complaint. And this was a point that actually made by Lord Justice Lewison in based on an article by Andrew Robertson in the case of Davis and Davis, where he was advocating for the second approach being more logical. And I'm not going to read that quite out because you can see what it says. And arguably this is consistent with fundamental underpinning of proprietary estoppel because what you're seeking to do, and what you can see from cases such as Gillett and Holt, which set out that the essential test is one of unconscionability, and cases like Jennings and Rice, is that the essence of the doctrine is to do what is necessary to avoid an unconscionable result. Now, personally, I do have some reservations about the removing detriment approach, because if we go back to our example of Charles, Charles may have been working at that farm for 18 hours a day, 6 days a week for the last 30 years. But for the sole, or for the predominant purpose of one day having something that he can pass to his children. As such, if that is the purpose, the quantification of his detriment becomes much more complicated, as paying him the difference between what he has earned and what he could have earned doesn't, in my opinion, do justice to that situation, because he's positioned his life on the prospect of having something tangible that he can pass to his children, and he's been deprived of that. Because, I mean, who's going to want to work 18 hours a day, 6 days a week for 30 years, if they're going to just be earning something that's not substantial? Therefore, I don't think that removing the detriment would provide him would be sufficient. Well, unless you're going to take the view that that you provide him with the means to buy another farm, I think that giving effect to the expectation is much more equitable in that situation. Now, I do have to accept that there's an obvious counter argument to this, which is if you have, say you have Susan, who is diagnosed with terminal cancer, and Susan asks her cousin James to come care for her, and Susan owns a hotel that's, say, arguably worth £3 million, and she says, if you care for me while I've got cancer, I will give you the hotel. Now, Susan dies after 2 months. Obviously, James is receiving a complete windfall in that situation, and the detriment that he's suffered is completely out of proportion. Sorry, the expectation that if you give effect to the expectation, it would be completely out of proportion to the detriment that he's suffered. So but that doesn't mean that you don't start with expectation. It just means that you need some sort of qualification or safeguard, such as you start with expectation if it's proportionate, and then you look at, and if it's not, you take a different approach. And there's and personally, I actually think that the point, Lord Justice Lewison was summarising this paragraph that I'm citing in this slide. Lord Justice Lewison was citing a number of different cases and the principles to be derived from those cases as a general statement of law. And I think he actually sums the position up very well, because he makes the point that proportionality, which is a point from Privy Council case Henry and Henry, is at the heart of the doctrine. And you'll of course be aware of the things like the minimum equity to do justice, phrases like that. And then he says that, but that doesn't mean you abandon expectations and seek only to compensate detrimental violence. You would do that if the expectation is disproportionate to the detriment. And I think that that's actually a good approach. That if one was to start with the expectation, you then look at whether it's proportion, whether the expectation is proportionate between to the detriment, and if it's not, then you look at how else you could compensate, and then you look at the detriment. But in doing that, you'd also need to take into a number of different factors. So because these cases are so fact sensitive, you'd need to consider things such as the clarity of the promise or assurance, because the more clear it is, the stronger the argument is for giving rise to expectation. You'd also, if you're receiving the money, because sometimes people will say, bring the claim during the person's lifetime, then there would need to also be an acceleration and so forth. But there are a number of different. It's an interesting case to see how the court's going to approach this, and yeah, personally, I would approach it from looking at expectation unless it's disproportionate, and then going to compensating detriment. But we'll see what the Supreme Court says. Interestingly, however, I actually watched the case on a Supreme Court channel, which if you've never done it, is quite good. It was interesting to note that Lord Leggett was making a point. It was very much of the opinion that if you're compensating for the detriment, then you should pay interest, which counsel was arguing against on the basis that the expectation was they would get something in the future, so why should you get interest? But it was an interesting point that that was raised. But yeah, as I say, this is all theoretical. We'll see what the court decides. Now, the next point I just want to briefly go through is in relation, because I appreciate that we're now at the end of the time. Our final topic is the administration is Section 50 applications. And as you'll all be aware, Section 50 applications provide the court with discretion to remove or appoint an executor, but they have to be exercised in accordance with established principles. And there are a number of factors that you would take into account in this type of claim. So, for example, you would consider the cost of replacing the executor in comparison to the size of the estate, because the replacement will usually be a professional executor. Another factor would be whether there's been any delays, the stage at which the probate's at, because if the probate's nearly complete, then there seems that there's usually little point in seeking to replace the executor, because the complaint is usually that they're not doing anything. But there may be cases where it's still appropriate to remove them. For example, if there's a suggestion that they've been acting, that there's some sort of devastat, or they've been acting in breach of their duties. You would also take into account the testator's wishes and the beneficiary's wishes, but the key consideration that one would take into account is the welfare of the beneficiaries and whether the estate is being properly administered. Now, that statement comes from a case called Leicester and Brewers, which was a decision, and the key passages in Lord Blackburn's decision or opinion. And that case is, Leicester is actually a case involving the removal of a trustee, but you'll see from Mr. Justice New's decision, as he then was, in cases like Kershaw and Micklethwaite, that the principle equally applies to removing executors, and it's regularly, this is the guiding principle that's also applied. Now, the point that we're going to look at in this webinar is the threshold, and it's not a point that's that's come up in the last year, but it's something from the last couple of years, and I think it's something that there's a little bit of a misunderstanding about, which is why I've included it at the end of this webinar. Now, there appears to be being argued that the threshold is now quite low, and I'm going to suggest that assertion takes the cases out of context, fails to appreciate the context of the cases. And there's two cases in particular that I'm talking about, and both are decisions of Chief Master Marsh before he retired. The first is Long Rodman, and the second is Schumacher and Clark. But to explain that point, I'm just going to need to provide a very succinct overview of some of the key points in these types of cases. So a good starting point in these types of cases is the citation that I put there on the side from Lord Justice Patton in a case which is called Rees-Savills Estate, but also known as National Westminster Bank and Lucas. And the important points to pick up from that passage is, firstly, the removal of an executor for the most part has to be justified by evidence that his or her continuation in office is likely to prove detrimental to the interests of the beneficiaries. And the second point to pick up from this passage is that the common theme in it is one of the common themes that you'll see in these types of cases, is that where there's mistrust or a lack of confidence, that will usually be insufficient to warrant the removal of an executor. However, where you have mistrust or a lack of confidence, it's usually coupled with friction between either the executor and the beneficiary, or the executors. And the friction in itself isn't going to be enough. And I've provided you with a quote from Lord Blackburn there, and one from Mr. Justice Hughes, who then was. Because you're going to have, in these types of cases, situations where the friction can arise. And a good example actually is Rees Savills' estate, because in that case, the executor had to try and balance the interests of the beneficiaries with the interests of a group of personal injury claimants. And obviously, whatever decision he made, whatever decision was made was going to disappoint somebody, and that will happen. But it's not enough to be a good reason to remove an executor. But if you're going to rely on friction, what you really need to be doing is you need to be focusing on how the friction is obstructing the administration of the state. Therefore, if you've got a situation like Johnny didn't help care for Dad, that's not going to be enough. The friction needs to be grounded, and it needs to be relevant to some way obstructing the administration of the trust or the welfare of the beneficiaries. And there was an interesting case last year, actually, called Hudman and Morris in front of Master Clark, where she acknowledged that a poor relationship between an executor and a beneficiary was insufficient to warrant the removal of an executor. However, she went on to find that in that case, there had been a significant hostility between the executor and from the executor towards the beneficiaries. And in light of that, she found that the executor couldn't be expected to display a reasonable and objective approach to matters concerning the beneficiary's entitlements, and therefore she ordered that the executor be removed. So the point that I was just mentioning, point again, is that the friction has to be directly related to the future administration of the trust. And another point I should just briefly mention is that not every breach of duty is going to warrant the removal of an executor. So I think Mr. Justice Newey used the example of if somebody's failed to produce estate counts, that's not going to be sufficient. What you're looking at is whether there is, well, this is where we get into the threshold point, which is in the case of Schumacher and Clark, the Lord's, Chief Master Marsh had he made a statement which was that if the court is satisfied that there's a good arguable case that there's been a breach, then that will usually be, or that might be sufficient to warrant the removal of an executor. And the reasoning that he was making that point was because it tends to be that tends to be a precursor to another type of action. But the point that one has to remember is, if you read the judgment, what he's actually saying is that the reason that you're removing the executor is because they're going to be put in a position of conflict, and that's not in the welfare of the beneficiaries, which is clearly sensible. And if you read those two decisions, you'll actually see that Chief Master Marsh refers back to another case of his, which is Earwicker, where he says that the jurisdiction under Section 50 is not to be exercised lightly, and although there is no presumption against change, the parties seeking the change must satisfy the court there are substantial grounds which are make a change necessary. Now, the just final point I'm going to make in relation to these cases are, if you have them in the High Court in front of the masters, the usual position in these types of claims in any event is that there's no cross-examination, because it's a Part A claim, you don't have disclosure, you don't have cross-examination. In London, particularly, they're not interested, usually not interested in there being any cross-examination. However, some of the High Court sitting in other locations is more receptive to it. But yeah, thank you very much for listening to me, and I hope you found it useful. I understand that there is a question, but I can't see what it was. Sorry, I did have I did have one question before. Somebody sent a question before the webinar, which was asking about whether you would need to apply for to remove them where there's a dispute. If the executors disagree on something, which was the question I was being asked about, it depends on what they're disagreeing about. I don't know what they are disagreeing about, but you can apply to the court for directions, but it's going to depend on what the disagreement is. But if you have a look at CPR 64 and the commentary, that will help provide you with some guidance, or also Williams and Mortimer will be quite useful in relation to that. Is there any other questions?
Christopher, I believe that Simon Lovelace had raised a hand earlier. Simon, are you able to make yourself known and unmute?
Simon, you okay? Your microphone's still on mute, Simon.
Just going to try one more time, see if we can get Simon to unmute.
I know Simon anyway. He can just give me a call.
Absolutely, we can follow up on that afterwards, of course. I don't believe that there are any more questions, but oh yes, Simon, sorry. If you would like to ask a question, then do perhaps write it into the chat box and we can certainly read that out. Just the last opportunity. Does anybody else have anything that they'd like to ask? Any questions? I'll just give Simon a chance to write a question if he would like to. I'm just checking. I don't think there's anybody else has put their hand up just yet. Do we have anything from Simon?
Well, you've all got my email address. If you do have any questions and you feel more comfortable emailing me, then please send me an email. And thank you all for listening, and also thank you to Finders for sponsoring the event.
You're most welcome. Thank you very much, Christopher. That was absolutely fascinating. You're a fount of knowledge. I did not know that there was a Supreme Court channel. I definitely need to find out more about that. Thank you very much, everybody, for listening in. And just a couple of points to remind you about. There's going to be a link to the recording of this session that's going to be sent out to everybody in the next few days. And also the Law Society would very much welcome any feedback from today's session or the sessions generally. So do please email Helen at helen.op@surreylawsociety.org.uk. Otherwise, I think that's it. Sorry.
I should just say the Supreme Court channel, the reference I was making to that is, if you go onto their website, you can click on recordings of the hearings that they've had. There's not a designated channel that you can go onto, but you can click on recordings. Sorry, that's what I meant.
All noted. Thank you. Thanks very much, Christopher. So I think that we will leave it there. Thanks again.
Thank you.